afternoon, good morning, depending where you are, good evening. I'm very pleased to welcome Florence Giselle and Professor Simon Deakin to contribute to this digit debate on the implementation challenges of the EU AI regulation. It couldn't be more topical as the EU have just announced today on the 19th of November their new proposals to simplify AI and privacy regulations. This has been drawing fire from the tech sector for not, and also it's been attacked by consumer groups who say that it's bowing to big tech. The digital omnibus package is going to delay strict AI regulations until 2027. It's going to ease access to the rules to let firms use vast data sets, including health and biometric information, for AI training without explicit consent, and include measures to cut red tape for business. So we couldn't have chosen a better day to have Florence to bring forward her insights into the work on how this EU AI regulation is evolving. Florence is currently visiting professor at Stanford's Cyber Policy Centre. She holds a chair in digital governance and sovereignty at Sciences Po France and is professor of private law at the University of Lorraine. Her research focuses on legal challenges raised by emerging technologies such as blockchain and the metaverse and evolving concepts of digital sovereignty. There are links on the Digit website to this event from her recent publications of Regulating Under Uncertainty, Digital Authoritarianism, and Statutory Obsolescence in the Age of Innovation. So thank you, Florence, for coming and sharing your insights into this very ongoing area of research. We're also very grateful to Professor Simon Deakin from the University of Cambridge to act as a UK perspective commentary on Florence's work, although he also has a very wide range of international experience and comparative research. Simon and his team provide an important contribution to the Digit Research Programme with their work on Labour Regulation Index, which is currently being used to try and understand the economic implications of labour regulation, both in the UK and in comparison with other OECD countries. So this particular talk today contributes very much to one of the new themes of research in our second phase of funding around issues of digital ecosystems and governance. So with no further ado, thank you, Florence, who is going to talk for about half an hour, and then we're followed by some comments from Simon, and then it will be open for Q&A from everybody else, and I'll take over chairing that when the time comes. But if you have any questions in between, you're very welcome to put them in the chat during the talk, and I'll pick them up afterwards or ask you to come in person. Thank you, Florence, and hello, good morning, California.
Good morning. Thank you so much for your invitation. It's a pleasure and an honor to be giving this lecture today from California. So I'm going to share my slides. Okay, so I think you're seeing them. Okay, so as a starting point, I would like to say that I started to work on AI regulation and AI governance a few years ago, but this talk is based on a report that actually has become a book that I released 1 year ago that is entitled Regulating Under Uncertainty, and that discussed what policymakers and regulators could or should do when they face the rise of a new technology that, of course, involves risks, but where all this happens in a very significant uncertainty because it's very difficult to assess the risks or even to know which risks are involved by the technology. And there is today, currently in California, a debate about the question whether it is necessary to wait for complete information for scientific risk assessments, or if regulators should not wait and act preemptively. So in Europe, in the EU, we have this principle that is important to us that we call the precautionary principle that basically leads us to regulate under uncertainty because we have this principle that basically says better safe than sorry. But here in California, where I am, it's a very, very vivid debate, especially today with the federal government, because California is adopting various types of frameworks, especially for the most advanced AI systems. And the federal administration does not agree with this approach. So I will not spend too much time on that point, but I need to highlight the fact that it is currently something that is being discussed here in the US, I would say all over the world. And so what Europe has decided to do is not something that everyone is currently doing. We have reasons, of course, Europeans have reasons to adopt this precautionary approach, but it's being criticized. And so this is what I would like to discuss today because the EU AI Act has been and is criticized for various types of reasons. And so this is what I would like to discuss. So if we start from, from the beginning, the very first question that we might ask when we want to address a technology and to regulate is, okay, so do we want to really regulate the technology itself? Do we want to regulate AI as such, which implies that we are capable to define what AI is? Or do we want to regulate the way AI is used? And I would say, well, the very first move of the EU and of everyone is to say, no, we're not looking at the technology itself. We barely know what it is. So we want to regulate what people do with the technology. And this has been the EU approach since the beginning, which is to say we want to look at the applications. We want to look at the sensitive types of application. And this is where we want to have a very cautious approach. So this was the idea at the very beginning. Um, and, um, and this is what you could find in the very first proposal of AI Act. That is usually, so this is the pyramid that is usually used to describe this approach. The European Commission looked at the various types of applications and said, well, you have some applications that are very, very risky, so risky that we cannot accept them. Some of them are high risk, just high risk, and we need to strictly regulate them, and others are fine. Some of them require transparency, but it's low risk or limited risk. And so this was the very first approach, which makes total sense. So I will not spend too much time on this, but since the very first proposal of AI Act, there was always a list of prohibited applications. Here you have this list, and I will not spend too much time on this. Maybe I could highlight one aspect here on that list. The very first line is about social scoring, the type of applications that you have in China, for example, but also person-based crime prediction. It's an important question here in the US because you might know that it's related to all those tools like Compass that predict recidivism and that are widely used in the US. And this is something that we do not want to have in the EU. There is, of course, another very important category, which is the category of high-risk AI systems. And again, here we are looking at applications, and we are looking at AI applications that are in use in specific sensitive sectors. So you can see that among those categories, you have categories that are already identified as sensitive or risky, like medical devices. But you also have various types of applications that are listed in the regulation, like critical infrastructures. If you use AI to supply water or gas. It is sensitive. If you use AI to recruit people or to manage people, it's also sensitive. If you use AI in the judicial system, it's sensitive, etc. So these are high risk, of course, and they require specific rules, and it's very complete. I cannot detail everything here because it's really very, very detailed. You have many rules that apply to high risk AI systems, various principles, guidelines. What I could say is that you really need to have a good data quality, a good information about the characteristics of your system. And of course, you need to follow how your system evolves over time. And for example, report the incidents that are related to your system. So the most stringent obligations in the regulation are for providers of high-risk AI systems. And again, I insist because here we are looking at applications. You also have a third category that is more limited in terms of risk, even though it's the kind of AI systems that we use on a daily basis, like ChatGPT. And so this is, of course, important because I think this will not be that easy to implement. The fact that we always need to be aware that we're interacting with a chatbot, that we need to know that something was AI generated, and we live in a world where you have so many AI generated content. Of course, for deepfakes, it's also important. And this, I think, is of major, it's critical because I'm not even sure that knowing that something was AI generated will prevent us from believing that it describes reality. And this will have an influence over what people think and what people do. And I'm quite concerned about these kind of questions. So this, this very first pyramid was in the very first proposal of AI Act, and it makes sense, and it focuses not on the technology itself, but on applications. But then, everything did not happen with ChatGPT. Of course, you had previously discussions about what we call today general purpose AI system, but as soon as ChatGPT was released, this raised the question of those big foundation models, those general purpose AI models on which those type of applications are built, because ChatGPT is built on a foundation model, a general purpose model that is GPT, today GPT-5. You have a bunch of them on the market. You have Gemini, you have Llama. And so these are models, not systems, models that are very powerful and that can perform various types of tasks. They can generate content, but they can do many things. And usually the applications that we interact with are not the models themselves. They are systems built on those models. The models provide the very first layer. And so the question that was raised during the course of negotiation was what to do with those general purpose AI models, because they couldn't be included in the pyramid, because the pyramid is related to, well, the very first pyramid was related to applications, and applications are considered on the basis of the purpose of the application. And here you have models that are general purpose. They have no specific purpose. They have no specific applications. They are just very general for deployers to build their own applications on them. And so during the course of negotiation, the drafter decided to include another layer of provisions. So you can see this at the very bottom of the pyramid here, specific provisions for those general purpose AI models that do not have a specific applications, a specific use case or application designed at the outset when they are being developed. And so this is why you have today in the AI Act provisions that really regulate the technology itself. Why? Because if there is a problem with those general purpose AI models, for example, if they are trained with bad quality data, then the problem related to the bad quality data is reflected in any application built on the model. And so this is of course critical. So of course when you decide to regulate the technology, this requires that you define the technology. You have a definition of artificial intelligence in the AI Act that basically is the one that was adopted by the OECD. But you also have definitions of what those models are. So you can see here on my slide the definitions that you can find in the regulation. What is very important here is that since it's very difficult to define those models and to identify them, the final, for now, the final criterion that was adopted by the EU Commission and by the drafters is to look at the volume of compute that is used to train those models. Which is criticized because it doesn't reflect any kind of risk. It just reflects how the model was trained. But this is how, for example, today the regulation identifies the the riskiest models, so the models that are considered with systemic risk. And I'm not very I'm not very convinced by this concept of systemic risk in EU regulation. It's also something that we find in the DSA. But basically, the idea is to say, well, there are some models that are really the riskiest ones. They are very powerful. And so if they have a vulnerability, this will impact the whole system. And again, the criterion is the volume of compute. So basically, it's really the most advanced and the biggest models. So of course, you have specific obligations attached to these models. It's important, mostly transparency, but also for the systemic risk models, good testing. So here is a basic overview of the AI Act. And I said it has been criticized. You can see the timeline for application. So you have no various provisions of the AI Act that have entered into force. For example, the prohibited AI practices are currently banned. Last summer, the provisions on general purpose AI models entered into force. But the next step, it's 2026, summer 2026, with the entry into force of the rest of most of the regulation, and especially the provisions on high-risk AI system. And this is where we are currently facing an issue. Why? Because, as I said, those provisions are the most stringent ones. And there was a report that was published last year by Mario Draghi. So he was the former president of the European Central Bank, who said, this is excessive. We're regulating too much. We're stifling innovation. This will be a bureaucratic monster. And so this has launched really a debate within the EU. And as a result, it has been decided, it has been considered to amend the AI Act to provide more flexibility, to bring a lower administrative cost. So I could say we are lucky, but it's just, I think the very last version, the final version of the digital omnibus package was released a few hours ago. So it's 8 in the morning here in California. I could just see a few of the final provisions. Here on my slide, you have the provisions that appeared in a leaked version that was leaked last week. But basically, as far as I can see, it is confirmed that the enforcement of the provision on high-risk AI systems, this enforcement will be postponed until 2027. The argument for this is to say, well, we do not have the technical standards ready to implement those provisions. You have other provisions in this digital omnibus package about enforcement, because as always, it's very complicated to implement and enforce those AI regulations, since you have mostly national countries, national authorities that are in charge, and they need to coordinate. And for example, in my own country, in France, you have different authorities that have jurisdiction over AI companies. And it's complicated to coordinate everyone, which explains why the EU wants to centralize enforcement as best as it can. And so this is why what is reflected in this digital omnibus. So you will have more centralization in enforcement, which I think is a good thing. Otherwise, it's too complicated for companies. And we'll see what will happen for the rest. The watermarking obligation for AI systems, so the fact that AI systems need to label AI-generated content. So this will probably be postponed as well. So this is a very important move. I wouldn't say that I'm that happy with this move. Why? Because it creates, we regulate under uncertainty, but the way we're doing it is creating even more uncertainty and legal uncertainty. I would probably defend the very principle of regulating, because I think it's important to have AI models that are developed safely, that are tested. But at the same time, we need clarity, and we need to have really a very a consistent stance towards AI companies. And so this really, to me, is not, I'm very critical, because I think we are harming, we're harming ourselves as Europeans. Of course, I'm talking as a European, but we have these concerns about stifling innovation, but sending, these very contradictory signs to the industry. I'm not sure that it's helping us. But happy to discuss this. So I will spend a few last minutes on GDPR, because GDPR is also difficult. It's also problematic when you look at AI, and especially generative AI. You probably recognize here Max Schrems, and you probably know that his organization, NOIB, None of Your Business, is really at the forefront of the claims against AI companies. Interestingly, NOIB, Schrems organization, doesn't care about the one-stop shop mechanism that you can find in GDPR. So basically, you have claims all over Europe brought before the national data protection authorities, and of course, you have grounds for these claims, because you have various. It's very difficult to apply GDPR to those AI models and systems. For example, it's very difficult to find the right way, the right legal basis for processing the data. You have a list in GDPR of valid grounds. Of course, we know that those AI companies scrape data. So they scrape data from all over the web, everything, including personal data. And it's very difficult to identify the legal basis for this. So they say, well, under GDPR, we could use the legitimate interest basis. This is what Meta said. This is what OpenAI said. So the European Data Protection Board finally said in December 2024, yes, it might work, but under certain conditions, you need to conduct an assessment And so on that basis, for example, OpenAI in the past was sanctioned by the Italian Data Protection Authority. So it's again, very uncertain, legally speaking. And of course, there is currently a litigation with Meta. Why? Because Meta uses um, user posts on Instagram and Facebook to train its models. So it's this has created various concerns. No, the rule is that Meta is using publicly shared data from adults on its platforms, but it's being contested by NOB. Um, there is another point that I would like to highlight regarding GDPR, which is the question of accuracy. And this is an interesting point because the principle of accuracy applies to any type of data processing, which means that it applies to um, the training of AI models. It also applies to the operation of AI models. But we know that the data sets do not always that are used for training do not always include the accurate data. They are gigantic data sets. So the AI companies, of course, they will not check that the data scraped from the web are always totally accurate. Um, and second, we know that AI tools hallucinate. So we know that AI generated outputs can be totally inaccurate. And so this is this could be considered as a problem under the GDPR. This is why NOIB has launched various claims before national data protection authorities saying, well, for example, ChatGPT keeps providing an inaccurate answer when we ask ChatGPT what's the birth date of Max Schrems. And so OpenAI says, okay, I could block any reply regarding to Max Schrems, but Max Schrems is a public figure. So people have the right to ask questions to ChatGPT about Max Schrems. And there is no other way. We cannot make sure that ChatGPT will always provide an accurate response. So this can be in certain cases, this can be even more problematic. This is a case that was brought before the Norwegian Data Protection Authority. It's about an output. So I'm so sorry here because it's written Claude on my slide, but it's an outcome that was generated by ChatGPT about someone who was presented of having been convicted of murdering his children, which was totally inaccurate. But this very response from ChatGPT triggered a reaction from NOBS that said, well, this is not compliant with GDPR because you're supposed to take every reasonable step to ensure that no inaccurate personal data is generated, or you should erase it or rectify it without delay. And so this is interesting because, of course, technically speaking, it's impossible to rectify the output given by ChatGPT. So basically, it's impossible to comply with GDPR in this respect, and so it's very difficult for me to say, what will be the what the solution will be. For now, the European Data Protection Board just said, well, maybe we should, draw a distinction between input and output. So we could say to AI developers, yeah, be careful with the data that you use for training. Make sure that the data is accurate, but for output, maybe we should just give up. And we should probably not apply the accuracy principle to AI outputs. But it's not clearly said for now. So again, it's very uncertain. So regarding GDPR, you have various proposals. You have the proposals, the Omnibus 4, that was released in May. That includes more derogations for smaller companies. But what is important is the digital omnibus that was released today, that includes many various amendments to GDPR. Again, this slide is about the leaked version that was published in the media last week, well, 2 weeks ago. I need the final one was released today, well, a few hours ago. But basically, you have various provisions that have an impact over AI systems and AI models. First, because this would narrow the definition of personal data. So if, for example, the data controller cannot identify data subjects with the data, then it might not be personal data. For example, if you cannot identify someone with an IP address, so then it's not necessarily protected. So it will be a very narrow, it would be a narrower definition of personal data that will make, that will probably make AI developers much more comfortable, because they will be able to include more data in their data sets without being preoccupied by GDPR. It confirms also that the legal ground of legitimate interest can be used by AI companies to justify training an operation, to justify using personal data to train and operate AI systems. And it's important because it implies that your consent will not be necessary. You also have a provision about sensitive data, special category data, that implies that anything that can be deduced through profiling or cross-referencing would no longer be considered as sensitive data. Which also has an imply with what AI companies could be authorized to do with your data. And even special category data could be used for AI training, testing, and validation if removing this sensitive data would require a disproportionate effort. So this is significant. These are very significant modifications of GDPR. The pushback is enormous. It's understandable, and I have very mixed feelings about these amendments, and I'm happy to discuss them with you. I'm not. My main concern about GDPR, it's the way GDPR is enforced, the way companies like NOB, organizations like NOB can bring claims all over Europe with various responses in Italy, in France, in Norway. This is, to me, problematic because we need to have consistent implementation. But here, this digital omnibus to me is really weakening, undermining the protection of personal data, and I'm not sure it will help the business or the European industry. And it will certainly affect users. So I would probably share many of the critiques that have been expressed so far. So I will stop here, and I'm happy to discuss all of this. Thank you so much.
Well, thank you, Florence, for absolutely fantastically super whirlwind tour over quite a complex area of regulation that's clearly evolving. But Simon, let me hand over to you for any comments that you have from a different perspective, maybe.
Thanks very much, Florence, for
Can I
that.
just also briefly say, if anybody has questions, either put them in the chat or put your hand up and we'll ask them after Simon's contribution. Thanks, Simon. Over to you.
Yeah, my feeling is the AI Act is not the most important part of this story. Product liability and labor laws are also important. The AI Act, like the GDPR, focuses on privacy, but doesn't address issues of power in the workplace, which labor lawyers and people concerned with digitalization of work should also be concerned with. The way AI is being used in the workplace, if we focus on that, essentially it's a very hazardous and dangerous technology because predictive AI using machine learning mostly doesn't work. We do know how it is supposed to work using machine learning. based on training data that's often undisclosed. That's a major problem. But if an employer uses, say, for example, an AI HR application, which is built on training data to which the employer doesn't have access because it's bought it off the shelf, if the employer uses that in a workplace to take decisions on dismissal, for example, they straight away run into problems with national dismissal law. There have already been cases at national level saying that dismissing somebody on the basis of a prediction from a kind of HR AI product is going to be an unfair dismissal if you can't explain why you dismiss the worker. That's existing labour law. And public safety law will come into play because the current state of AI, the best way to think of it, in my opinion, it's like a fantastically dangerous machine that's not been properly fenced circa 1830 or maybe 1890. So AI law or digital law is at the stage that labour law or tort law were at a century ago. Digital law is having a debate about whether you need to give your consent to data being processed or whether you have a right to an explanation about how it's going to be processed, and then you give your consent, and then it is used. Labour law and private law a long time ago said, even if you give your consent to working alongside a risk like that, you're working in a very dangerous factory, for example, or a coal mine, your consent does not absolve the employer of liability for the harms it may cause to you through the operation of the machine. So that's where a lot of the action will be, I think, on the labour market side and increasingly on the tort law side. As far as the EU law is concerned, changes to the product safety regime connected to AI are very interesting. They go further than the AI Act does. And the Platform Work Directive in the labour law field goes significantly further than either the AI Act or the GDPR do in terms of demanding some degree of oversight of automated decision making. But even so, these measures don't provide what should be provided, which is a right to compensation for harms caused. We already know from the use of predictive AI in social security law, for example, that fraud detection systems, we see even this week, fraud detection systems going wrong in the UK when people are falsely accused of leaving the country so they lose their child benefit, thanks to a basic error in the way HMRC systems are working. The post office case, which can't even be called AI, but is misuse of computational knowledge, the Siri case in the Netherlands, and other cases like Robodebt in Australia, have already demonstrated the huge scope for social harm, which can be caused by the uses of AI. It's not always physical harm, which can be a problem, because often you would need to point to physical harm to have a tort claim. It's often economic harm. But let's not forget that in the Siri case, the misidentification of families as being involved in benefit fraud led to children being taken into care and even suicides. So there's real harm there. The post office case is the biggest miscarriage of justice in the UK practically ever. So I think that the action will increasingly be in areas where we already have law, private law, tort law, labour law, and it's very important that those areas of law are in no way prevented from evolving by the idea that somehow data protection law or the AI law expresses the maximum obligation upon employers. If this is a ceiling of rights, then we really would be in difficulty, because AI law at the moment is about where these other areas of law were in about 1870, in my view. So it really does need to evolve quickly to catch up. Thank you.
Wow, that was a fantastic, speedy commentary with a lot of interesting points. I've got some questions, but I can see somebody has in the chat. Oh yeah, will we share the slides after the webinar? I think we will, but a recording of this will be available on the Digit website. Does anybody, first of all, have any questions they would like to ask either of our speakers? If you want to put your hand up or put your hand in the chat. Okay, I had two questions which I'll kick off on, and I was actually really interested. I enjoyed both presentations. Actually, the first question I'm going to ask, well, is going to be to Florence. So, who would you say are the key actors in the digital ecosystem that are developing these practices? Because this is a concept we're interested in our research centre under research theme 1 about the governance of digital ecosystems. So who are the key players? Secondly, I know you've just come back from Asia, as has Simon as well. How are those kinds of countries reacting to what's happening in the EU? And I know from work we've done with my colleagues Rachel Verdin and Rooney Halverson, some European countries just do what the EU tells them to do. Some of them protest a bit. So even within the EU, I won't name those countries, but they just say, well, we'll wait till the EU's decided what we want and then we'll do whatever they tell us. So the constellation of ecosystem actors at these different levels is quite varied. So that's the first two questions to Florence. Who are the actors and what are other countries learning from what's happening in the EU? And I've got another quick question to Simon. And I'm glad you made reference to these historical precedences of health and safety in previous periods of industrialization, because I was going to ask what can we learn from how health and safety in that early industrialization phase, what do we learn about how people were protected in mines and mills that might teach us about what this unknown quantity of this phase of industrialization or digitalization might mean? So maybe you've mentioned some of them, but I think it'd be really helpful to have that historical perspective as to where we are. You're saying we're back in the 1830s, 70s, but that's what be nice, I think, to hear more about what you think of that. Florence, shall I ask you first what you think, who the actors and what are other countries learning? And then if anybody else has questions, put them in the chat.
So yes, so when you say the actors, you mean the actors, the AI actors, the AI players, or the actors in the implementation part?
I mean the human beings. So whether they're policymakers, whether they're companies, whether they're the consumer groups or trade unions, or who's having the key influences in the way these debates are evolving and being implemented?
So this is an important question because you have, and I think it's, I'm not, I'm not an expert of, I do not, my research focuses on the law, so I do not follow specifically lobbying or influences, but it's very interesting to see how, and those EU regulations are drafted and who is around this. Because the negotiation process and the drafting process involved various types of actors. You have many very, very active NGOs. And it's important, those NGOs are very present here in the US. You might have heard of this very intense debate between those people that we call the doomers and those people that are called the accelerationists. So these are basically those expressions are oversimplify the reality, but basically you have some experts that really highlight the risks of AI and even this idea that AI could destroy humanity, and people that really reject this claim and say that no, AI will improve humanity. And so this is a very intense debate here, especially here in Silicon Valley. But you can see over those EU debates and processes, you can see various NGOs that are very much involved in this debate. So you have the NGOs, what we call the stakeholders. Of course, you have the industry. The industry is very, very present. And so you on a regular basis, you have people that complain about the fact that, Google discusses directly with the EU. But at the same time, it's important. And this is why there is a very important asymmetry of information between those tech companies and regulators and policymakers and the population. And so one phenomenon that is interesting is what the EU decided to do to implement the rules on general purpose AI models, because they decided to draft, they decided that codes of practice should be drafted. And so they decided to involve more than 1,000 stakeholders in the drafting of those codes of practice. So this has happened for general purpose models. This will happen for AI generated tools. There will be a code of practice for this. And the idea is to have everyone around the table. But of course, you have criticism. It's a very long process. You always have this risk of regulatory capture. So yes, so what my conclusion would be, well, what the most powerful actors in the whole system are not policymakers. They are the ones that have information. And the ones that have information are the players that are currently developing the most advanced AI tools, OpenAI, Google, Meta to a certain extent, because they have the information and they're doing everything they can to be as opaque as they can. Regarding your other question, so when you look at what Asian countries are doing, they are civil law countries. So they're not, regulating the way Europe, well, the EU is doing, is not that problematic as a matter of principle, but they do not want to have a comprehensive regulation with complicated legal definitions. So, for example, you have in Korea, a new statute that was adopted, that was voted in 2024, where you have a list, a very pragmatic list of high-risk AI systems, like AI systems used for nuclear facilities, supply of energy, etc. If you're interested, I can send you the list or include the list in my slide. But you have also a law that will be adopted in Taiwan. But my impression, because I had the occasion to meet with people running the AI Safety Institute in Singapore, in Japan, they are much more pragmatic. And what they think is that they can discuss with AI providers and AI companies, and try to draft guidelines that are not necessarily mandatory, but that can, if they are well informed, influence the industry. And also, since the biggest AI models are not developed in Asia, basically most of them, they'll use the Chinese one. China is another story, but they know that they will have, or they have to use AI models developed elsewhere in the US, in China, and build their own application on them. So there is a part of the AI industry that will not be regulated by them. They try to focus on applications and systems.
Great, thank you very much for quite a complex program. Simon, with your historical perspective, you're basically arguing that AI regulation at the moment is stuck back in the 1830s and 70s, and what we need to be looking at is contemporary regulations around employment, tort, and private liability. Do you want to tell us what you think about it in more detail than you had a chance to do in your commentary?
Well, even Marx in Capital argued that actually the factory acts were responsible for promoting innovation because the less efficient firms went out of business once they were unable to comply with the first laws on hours of work and later on machinery being fenced. But not just Marx. Schumpeter in the 1940s argued that innovation required controls. He called them the brakes in a car and was thinking about IP law. So neither Marx nor Schumpeter would have been in favor of a complete free-for-all for AI today. And in fact, the only people who are in favor of a complete free-for-all are the AI tech firms themselves. So we just have to see special pleading for what it is. It won't be promoting innovation to remove controls. It will, of course, cause a backlash if people are completely unprotected from obvious hazards. I guess the last thing I've heard from John Norton recently was that certain tech firms in California are worried that in the very near future, they will be seen in the same light as the opioid firms. So even their own self-interest might indicate the need for some self-regulation. But of course, this is very path dependent. And for a little while yet, at least, this accelerationist argument will be made that we should just scrap everything, and then eventually AI will solve everything. I think we've been here before. We've been here before several times in the past, in the course of industrialization. Sure. Large firms always want exemption from regulation, or regulations which protect them from competition. Regulatory capture is a real issue. Whenever OpenAI says they want regulation, we can be fairly sure it's because they think it's a way of keeping competition low.
Very, very interesting. Thank you very much. I have two questions in the chat, one from Cassie Bokert and one from Wilson Wong. So would you both like to open your mics and ask the questions directly to our speakers? First of all, Cassie, would you like to start, and would you like to briefly introduce yourself as well?
My name is Cassie Bokert. I'm at the University of Manchester. I'm part of Digit. My question was really, given that a lot of the firms that are adopting all these AI tools that we're talking about are often doing so as either a software as service model or off the shelf, and typically that model involves them providing their company data to the technology providers to train the tool or the system for their particular work processes. I was wondering who's considered the data controller legally in that context, and where does accountability sit for ensuring data accuracy under the law? Is it the employer or the tech provider? Thanks.
Maybe is it best to, I think the questions are going to be quite complicated, so maybe if you want to answer that one first rather than collect all, there's another one come in. Do you want, maybe Florence, is that for you to answer, or?
I can try to provide an answer. It's a very complicated question. So basically, this is a complicated question because you might have a model that is already trained. So let's assume you have an AI model that is already trained with data. And so the question whether this model includes data that is stored is still being discussed. For example, here in California, the Data Protection Authority considers that having a model that is trained with personal data makes the data anonymized, and so you do not have necessarily something that includes personal data. So when you train the model, when you use the data to train the model, of course you're the data controller. When the model is trained, it's a little bit more uncertain. So then you assume that there would be, let's say, a company that will use a pre-trained model to fine-tune it for a certain application, and in the fine-tuning process, you will have more personal data used to fine-tune the model. And in this case, I would say that it's the company or the employer or that is using the model, that is operating or fine-tuning the model with personal data, that is the data controller. And so who is responsible for ensuring data accuracy? This is a problem when you look at outputs, if you're using a generative tool. And so I'm not sure I could answer that in a few minutes. I'm not sure I can provide an answer.
Okay. Simon, do you have anything you want to add to that briefly?
The answer lies outside AI and digital law, and the question of exactly who is a data controller or a data subject matters less than one might think. What matters for labour law is who is the employer, who is the employee, what rights do they have. So if an employer uses AI to make a decision, they're still the employer. The Platform Work Directive identifies digital labour platforms and in the background employers as potential entities that can be made liable for the misuse of AI. And tort law will impose obligations upon entities that market AI, whether or not they are data controllers. So data protection law is really about privacy and cuts across labour and tort law. Is kind of orthogonal to it and doesn't address, as I say, issues of power very well. But other areas of law might do better. So in my view, it is complicated to answer the question because data protection law is really complicated and very granular. But its complexity is not the only issue here. And law is not just the law relating to the digital economy is not just digital law.
Thank you very much, both of you. Well, Wilson, would you like to ask your question and briefly introduce yourself? And then after that is Andreas and Abby. Wow. Obviously stimulated.
Thanks, Jackie. Wilson Wong. I'm part of the Digit Advisory Board. I guess you mentioned, Florence, earlier about the fact that China is distinct because it is a producer, a major producer of AI systems. So I'm just wondering, given that China is now very, very active in setting global standards in a whole plethora of domains, is there any observation from your perspective how they are seeing their ecosystem and whether there are any distinct characteristics which perhaps from a European perspective we're not so familiar with? Thank you.
Thanks for this question. It's so when I was traveling to Taiwan 2 weeks ago, there was a very interesting interview of the CEO of NVIDIA, Jensen Huang, that declared to the Financial Times, the US the US will lose the AI competition. China will win. China is about to win the AI competition. And so this created a significant reaction, especially in Taiwan. But what is interesting with China is the fact that China has been regulating the digital sphere for the past years. So you had every year you have a new framework that is adopted by the Chinese government, but it's mostly focused on information. And of course, the Chinese government is very preoccupied with AI-generated output, and so wants to regulate how those AI tools are trained. They want those tools to be trained with content that is not that comply with socialist values, and I'm quoting the regulations here. So this is basically their preoccupation, because they do not want any AI output to be to contradict socialist values, to put it very, very to oversimplify things. But at the same time, China and the Chinese government helps AI companies. So they have safety standards. So they release safety standards. They move fast. They are not, technically speaking, mandatory. And so the Chinese government is really much helping its AI companies, especially because they provide energy at a very low cost, even for free sometimes. And of course, if you have electricity for free, you have a significant advantage as a developer. So this is what's currently happening. And so you have very, very sophisticated AI models that are being developed by China. They're open source. They're available for free. You have many, many companies in Asia and elsewhere that are currently using these models. This may be considered as problematic because it's very difficult to determine how those models were developed, tested. And so this may, if you mention the consequences for citizens, yes, we are starting to see a world where many AI companies are building their tools on the top of Chinese general purpose models. So this is problematic. And so last point about the US. In the US currently, so you have a federal administration that doesn't want to regulate, that want to pour trillions of dollars in the AI industry. There is clearly a bubble. But at the same time, you have states that are regulating. So California regulates, Colorado has regulated, Texas has regulated. And so this is what the industry is currently highlighting, saying, well, so we do not want a regulation at federal level. We are starting to have regulations all over the US at US states level, and this is harming us. And so this is the present debate here in the US. And so these are also the arguments that are used by the industry to say, well, if we continue like this, China will win.
Simon, did you have anything? You don't have to add, because there's a couple of other questions coming up as well. But
I'm fine,
if
thanks.
you want to. Okay, I'm going to ask Andreas and Abby to very briefly, if you can, ask your questions. Andreas was next. We're going to run over a little bit. Sorry, we're going to run over a little bit longer just because there are questions and because it was a very rich debate. So, Andreas, over to you.
Thank you, Jackie. Thank you, Florence and Simon, for the very provocative debate. Very quickly, I was trying to pick up on something that Florence mentioned about Mario Draghi's report and the criticism that his report received. The point that Mario Draghi made about AI Act over-regulating and sort of stifling innovation. And I was wondering what are the politics there, and was the behind the debate or the criticism was the idea that European companies who would like to get into the race of the AI would not be allowed with so much regulation, or was that AI regulation was mainly targeting US companies, and how this evolved? If you have any input on that, thanks.
Okay, Abby has had to go to another in-person meeting, so that will be our last question for today. And so I'll hand over to Florence and Simon to see if you want to answer that and any last comments you may want to have about future directions for research in this area. Over to you, Florence, first, and then to Simon.
It's difficult for me to assess the politics behind Mario Draghi's criticism. I think he reflects a preoccupation that is shared in the in the private sectors by not just AI companies, but by many European companies. During, when the AI Act was being drafted, you had open letters signed by a bunch of major European companies saying this will harm us. So it's difficult for me to develop on the politics. What I could say is that I read his report. I think some of the criticism were clearly justified when you look at the way GDPR is implemented. That we clearly have an issue with the way GDPR is implemented. Europe, it's too fragmented. So to me, the main concern is fragmentation more than over-regulation. Yes, so for GDPR, I would gladly approve the criticism. I think he was a little bit unfair about the AI Act. Because the AI Act, especially for the general purpose model, is mostly about transparency and testing. How can you criticize this? So this is my personal opinion about Draghi's version. So Jackie, you said about next research or future projects. So my last point would be just to say that I'm starting a new project on the coverage of AI risk by the insurance industry. I think the very next topic will be AI liability. I haven't mentioned the claims against the AI tools that were launched in the US, but you might have heard about those teenagers that committed suicide after interacting with a bot. This is of major importance. Those tools are going to have a major influence over our lives. And so my impression is that at the end of the day, those companies need to be aware of their responsibilities. OpenAI has no insurance coverage for these claims. And OpenAI is currently counting on just, paying the families from time to time. And that's over. And so this is why I decided to start this and trying to see what the insurers are currently doing in that sphere, because at the end of the day, insurers have a significant role to play.
Absolutely fascinating. Simon, would you like to make any last comments on your interpretation of what Florence said, your own opinions, etc., and where you think we should be going with research in this area?
No, I think I completely agree with what Florence has just said about the role of insurance, and the focus will shift to litigation, especially in America. Even if there's no regulation or little, it won't stop litigation unless, of course, the AI companies negotiate some kind of extraordinary safe harbor for themselves, or get the government to insure them. That's also what they may be thinking of. But the scale is difficult to conceive, isn't it? I think that the idea that we'll promote European innovation by deregulating is the same argument that was made a century ago in Britain about why we couldn't any longer comply with the Factory Act, so we had to downgrade them by many manufacturers as continental European producers in Germany overtook British ones. British firms said, well, we need to scrap our regulations now. And they did begin to weaken them in the 1890s. That argument didn't help the UK a century ago. Okay, so the idea that somehow not regulating is going to be a basis for European competitiveness is very short-sighted. And if China is going to succeed where the US and Europe are failing, it will be because they have grasped the nettle of effective regulation. We must bear in mind as well that the state played a major role in creating the AI sector in the first place in America. It's not just venture capital, it's DARPA and state funding for AI, which has been critical in America, right? Okay, so the EU should be focusing less on the AI Act and worrying about competitiveness than, I think, taking seriously the role of procurement, of industrial policy. They're beginning to think about this, aren't they, a little bit? And also asking the question of whether a purely venture capital funded model is really the right way forward, given that, again, in the US, there are lots of serious questions being asked about perverse incentives arising from venture capital funding. And indeed, here in the UK too, the supposedly successful Cambridge phenomenon model, in fact, depending so critically on venture capital funding, is leading many UK tech firms, including in the AI area, to be prematurely sold to overseas competitors. So I think a serious look at venture capital is needed. Whether the EU is capable of that remains to be seen. But I don't see why it shouldn't grasp that nettle. That would be more useful than worrying about the omnibus idea, which is largely performative.
Well, can I thank both of you for providing a massively stimulating and rich discussion of this really important issues. It's great to have your expertise, Florence. It's also great, Simon, to have your different perspective in how it relates to historically and other types of legal regulation. Can I thank also the audience for coming and in joining in, and of course not forgetting two important groups to thank. One, our team at Digit, which is Alex Mason and Gemma Smith for helping run the whole show, and thanks to the ESRC for funding this in the first place. So I hope you'll follow us for next season in 2026, when we have a whole series of other debates to follow on. And have a happy Christmas when it comes, or Thanksgiving, or whatever it is that you do, because this is the last one for this year. Thank you, both of you, very much. And thanks everybody else. All the best. Bye-bye.